Hello and welcome. My name is Peter Afrasiabi. This is me, well, sort of, it's my avatar. I recorded a short audio and video snippet of content of me, and then can recreate myself and my voice through software. So this is not a deep fake of either me or my voice. Instead, you may call it a real fake, I guess. All the content you hear is mine, and the voice is mine, and the person you see is me. Just it is me, digitally recreated, and fittingly, we are using this technology in a program that explores the challenges of the technology as we enter this AI world. I am an intellectual property litigator at the law firm of 1LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today, we will look at a variety of issues then from the realm of deepfakes. Questions about federal and state legal regimes, how to regulate it, efforts underway to regulate it, and existing legal regimes that do touch on it already. And we will see both good and negative uses of it by right away looking at two of our famed actors, Val Kilmer and Scarlett Johansson, and seeing the technology at work as it applies to voices. We will also learn about political deepfakes with Harris and Biden cases in the California federal courts and before the FCC. So sit back, enjoy a cocktail while I have a virtual one, and let's get going. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. Here is our agenda for the day, to learn all there is about deepfakes as they collide with the law. We will look at real-world examples of deepfakes to understand what they are and how they work. The first question is, what are they? Deepfakes are AI-generated videos, images, or audio that convincingly depict real people saying or doing things they never did. This raises for us as lawyers, of course, real legal issues. It presents novel challenges to intellectual property frameworks and state publicity rights structures. We will look today at existing laws on the books to regulate deepfakes, and then a range of new state and federal laws being passed or pending to address deepfakes as legislatures race to catch up with our technologists. And we will look at the constitutionality of some new laws seeking to control deepfakes in political satirical speech. All of this raises fundamental issues about ownership and adequacy of existing legal protections in this rapidly evolving AI age. So let us begin, as I promised earlier, with two examples of the technology that sits beneath deepfakes. One positive, one negative. One of a consent use that shows how great this technology can be, and one a use of the technology in a deepfake sense to evoke an actress's voice and persona. I told you in the beginning that this technology can be used both for good and ill within the framework of our legal system, and so I want to talk about both cases right away. First, a positive example of this technology out of the gate. This is the situation involving Val Kilmer, and this is a positive story as it relates to the legal regime, as well as just being a positive feel-good story, but specifically, it's a situation of artificial intelligence learning Val Kilmer's voice with his consent. So what you need to know by way of background, if you don't already know it, is that the famous actor Val Kilmer had some sort of an illness that had damaged his vocal cords such that he could not speak in his familiar, well-known voice. Now, 20 years ago even, that would be the end of an actor or a voice actor's career, obviously. But not anymore. With artificial intelligence, because Val Kilmer was able to have his voice recreated by listening to and learning off of historical recordings of his voice by way of a company called Sonantic. So check out this YouTube video, which will show you the most amazing technology in terms of voice and artificial intelligence.
We all have the capacity to be creative. We're all driven to share our deepest dreams and ideas with the world. When we think of the most talented creative people, they speak to us in a unique way. A phrase we often hear is having a creative voice. But I was struck by throat cancer. After getting treated, my voice as I knew it was taken away from me. People around me struggle to understand me when I'm talking. But despite all that, I still feel I'm the exact same person.
Now there you saw the case of consent and a really positive application of the technology to allow an actor to continue to work even when his voice was gone. But I also want to stand and deliver out of the gate and show you the opposite case that we will be exploring as this program continues today. So let's take a look right away at the Scarlett Johansson voice situation that led to a controversy because it was not done with her consent. I'm not going to answer all your questions right now about how this collides with the right of publicity, but they will all be answered by the end of this program. So check out this video released by OpenAI showcasing their virtual assistant named Sky. You need to watch and listen to this to understand the legal and factual questions the law will need to answer. That voice you hear is not Scarlett Johansson's, but if you listen, it really does sound like her, at least if you ask me.
From right of the ChatGPT app, and this will open up GPT-4o's audio capabilities. Hey, ChatGPT, I'm Mark. How are you?
Oh, Mark. I'm doing great. Thanks for asking. How about you?
Hey, so I'm on stage right now. I'm doing a live demo, and frankly, I'm feeling a little bit nervous. Can you help me calm my nerves a little bit?
Oh, you're doing a live demo right now? That's awesome. Just take a deep breath. And remember, you're the expert here.
Let's do a quick overview of our current legal landscape that we will be diving into. We start at the top of the pyramid, where there is the least amount of federal laws touching this area. Some laws that may touch it are the Lanham Act, Copyright Act, some federal telecommunications acts and Communications Decency Act in terms of material, That's defamatory, sitting on service providers' platforms and the difficulty of getting that down or holding them liable. All of those laws touch at some level some of the deepfake issues, but they don't get at the root issue that's related to our deepfake inquiry. We won't go into detail on these existing laws, but we will look at pending federal laws to address this on a national level as it relates to deepfakes and false political messaging or sexually explicit material, all of which is created by deepfake technologies. This brings us to state right of publicity laws. And here we have the regimes that exist to protect against commercial misappropriation of someone's name or likeness or image or voice. Here we will look at the existing legal playing field as it relates to state laws, and then we will look at new state laws that have been passed to address deepfake situations. Finally, at the bottom of the pyramid is existing state tort laws that deal with defamation and infliction of emotional distress and the like. Those all are subject to our federal laws that restrict suits at least against service providers with broad stroke of immunity under Section 230 of the Communications Decency Act. The point for you here is that we have a very fragmented playing field in terms of the legal landscape that applies. There is no comprehensive all-in-one federal law that actually addresses deep fakes head-on, and this creates fundamental challenges for people who are seeking protection, and at the same time, for companies that genuinely want to avoid different and inconsistent liability regimes so that they can do the right thing. One of the questions that ultimately calls for is whether it is time to nationalize the state right of publicity, along with the sexually explicit deepfake laws, and preempt the field with a universal federal cause of action. Let's look quickly at the online immunity laws in Section 230 of the Telecommunications Act. How does this federal law we see here relate to deepfakes? Here is how it does. When deepfakes go up on social media platforms, getting them down really matters. And the service provider has a range of immunities from state legal regimes. This explodes in the deepfake era, of course, so let's look real quick at the federal laws to understand their deep immunity reach. Immunity for the service providers, that is. So Congress, way before deepfakes, and really even the internet as we know it in the second decade of the 21st century, enacted Section 230 of the Communications Decency Act in 1996. We see it here on this slide, and it is codified at 47 U.S.C. 23C, and this is the money language we have quoted for you. This is the core of what is central to online internet immunities today. Quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." End quote. If you read it twice, if you have to, you see it is very, very broad in terms of absolute immunity. And further provisions provide that it ends up preempting any and all state claims based thereon. Here's the definition of what an interactive computer service is, and that's the same basic definition we're using for online service providers as we talk about this in the copyright realm, which we will address soon. But basically, quote, interactive computer services, end quote, refers to information services systems or access software providers that provide or enable computer access by many users to a computer server, including a service or system that provides access to the internet, and such systems operated or services offered by libraries or educational institutions. It's very, very broad, and so what it means is it's Verizon or Cox Internet, it's Yahoo, it's Google giving search, giving email, kind of the backbone access provisions. And then in the more modern sort of Internet 2.0 world, Facebook, Instagram, Snapchat, those types of businesses that have gone a step further but are still built on facilitating communication between people over the internet. Let's go to the next slide, which brings us to the twin goals of Congress with the Section 230 immunity that Congress created in 1996. The first goal was that Congress wanted to encourage the unfettered and unregulated development of free speech online and to encourage e-commerce and its development online. In other words, the development of business and e-commerce type activities online that help everyone. The second goal, by enacting this immunity provision in the Communications Decency Act of 1996, was to, quote, encourage interactive computer services and users of such services to self-police the internet for obscenity and other offensive materials, end quote. These are two massive goals that frame the statute and its interpretation over the ensuing decades. This brings us now to one of the first major cases to come down after the law's enactment. And it's really one of the foundational cases in Section 230 law. After the enactment of the Section 230C immunity, this is the case of Zoran versus AOL. And so now we're bouncing from Prodigy, which precipitated the need to pass the Communications Decency Act provisions, to AOL, which was one of the first ones to be sued after they were enacted on a state tort liability theory. And this case involved an unhappy plaintiff because this is what happened, as you see in the facts. There was a false advertisement placed on an AOL bulletin board, and the false advertisement directed users to call up the plaintiff. And this obviously resulted in the plaintiff receiving endless amounts of harassment and calls and whatnot at his phone number. Plaintiff was not happy, as you can imagine, being bombarded by harassing phone calls, and so the plaintiff sued AOL saying, "This is your bulletin board. My personal phone number was published on it, and it's obviously harassing. And given the content and nature of it, you should have taken it down. You didn't. And that resulted in me suffering emotional distress and other state tort-based claims and damages." Plaintiff sued, and here is what the Fourth Circuit held. Congress recognizes the threat that tort-based lawsuits pose to freedom of speech in the new and burgeoning internet medium. But the imposition of tort liability on service providers for the communication of others represented for Congress simply another form of intrusive government regulation of speech. Thus, Congress made a policy choice not to deter harmful online speech through the separate route of imposing tort liability on companies that serve as intermediaries for other parties' potentially injurious messages. The case thus held immunity, and so one of the central lines that traverses that holding, as you can see, is that AOL is simply an intermediary. It's a facilitator of communication. It is not really engaged in curating the content and editorializing the content. In publishing the content, the same way the New York Times makes those conscious, volitional business decisions about what content it's going to publish, it's really an intermediary. That is, it's just a service provider providing a means of communication. Therefore, if I defame you, then you can sue me. You can do your discovery, and you can find out who I am, and you can go after me the same way you have always been able to go after me under state tort law. You just can't hold the internet company liable. This case is a seminal foundational case when it comes to online social media liability principles. And so you can immediately see the dilemma we confront with these online providers and their immunity as we enter now a world with deepfakes spreading on their systems, causing immense damage. Let's now address the state right of publicity regime that most directly relates to deepfakes. This right against another's commercial misuse or misappropriation of one's likeness existed at common law in various states over the subsequent decades and began being codified as positive law in various states also. For example, in California, it was codified in the 1970s. It's now recognized in over 35 states, and what is critical to keep in mind is that this is a distinct right to copyright or trademark, even though it has similar issues and touches on similar concerns. The existence of this right in the state courts eventually reached the U.S. Supreme Court in the late 1970s. This was a case involving the famous human cannonball. You can see the case there, the case and its citation, so you can read it later, but basically what happened is as follows. The human cannonball had an act that he made money performing. He would drive his large truck that had a cannon attached to it, wear his cannonball suit, climb into the cannon, and then get fired out of it. He would fly through the air, flip, and land. That was his whole persona. It took only 15 seconds, and he made his living by charging to watch the short event. So for him, the 15 seconds were everything. What happened is that a reporter video recorded the whole act and played it on the news. The human cannonball then filed a lawsuit under Ohio's right of publicity laws, claiming that his persona, that is his act that he did, was that entire short video sequence, and showing that to the public abridged his rights. The news organizations claimed a First and 14th Amendment right to broadcast this as news. But the U.S. Supreme Court rejected that argument and found that he had that right that was free from complete exploitation. Now, what is important for our modern artificial intelligence age, in light of the fact that the U.S. Supreme Court has only addressed the right of publicity and the First Amendment one time, is the fact that the decision was a 5-4 decision. And the legal fault line the decision hinged on was the fact that the news organizations engaged in conduct that amounted to an entire taking of his performance, as opposed to merely reporting upon it, which would not require such an extensive taking arguably. This is what the U.S. Supreme Court said. Wherever the line in particular situations is to be drawn between media reports that are protected and those that are not, we are quite sure that the First and 14th Amendments do not immunize the media when they broadcast a performer's entire act without his consent. On the other hand, the 4 dissenting justices took the position that it was genuinely news activities and therefore protected by the First Amendment. The dissenters stated as follows. Quote, "There is no suggestion here that respondent made any such use of the film. Instead, it simply reported on what petitioner concedes to be a newsworthy event, in a way hardly surprising for a television station by means of film coverage. The report was part of an ordinary daily news program, consuming a total of 15 seconds. It is a routine example of the press fulfilling the informing function so vital to our system." End quote. The decision was from the 1970s, but here is the breakdown of who the dissenters were. This is important to us as IP and right of publicity lawyers because we want to try to read the tea leaves about how today's court would rule. The 4 dissenters were Justices Marshall, Brennan, Stevens, and Powell. In other words, the liberals of the court of that era by and large. Now, the majority was Justices Berger, White, Rehnquist, Stewart, and Blackmun, the conservatives by and large. But you will note that it was not a purely right and left split, given where Powell and Blackmun came down. So it is an important decision, but we can also see that it was a very closely decided case that hinged on a very unique and arguably extreme fact pattern in terms of the entire taking. Nonetheless, this decision really coincided with the floodgates opening in reality to the modern right of publicity age in terms of protections and monetization of it. This has led to further enactments of laws in various states, which also include rights in some circumstances for broadcasting, but not the right for a complete taking of someone's persona in general. So let us now unpackage this right a little bit more. We will look at the California statutory right, which is codified in California Civil Code Section 3344. It protects against an unauthorized use of a person's name, likeness, voice, signature, and/or photograph in commercial advertising. Subsection A provides that any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling, or soliciting purchases of products without the consent of the owner is liable for damages. There are augmented damages and punitive damages available, along with attorney's fees also. So it is a powerful right that gives remedies if it is abridged. And as applied to deepfakes, it applies foursquare to digital AI-based deepfakes created and then used commercially. But note it has limits, as it is a right that protects against commercial exploitation. Its application, for example, to deepfakes that are revenge porn type things that do serve a commercial purpose may make regulation of such acts of appropriation outside the statutory framework. As I mentioned before, there are some statutory limits that have been enacted. For example, California has an explicit exception for uses in connection with any news, public affairs, or sports broadcast or account, or any political campaign. This allows news broadcasters to show, for example, athletes either in public or in clips of them playing, without being sued by them for right of publicity. But remember, the human cannonball case still stands as good law, so a complete taking of someone's persona, which is their entire economic persona value, would create an issue. There are further statutory exemptions from liability for uses in a play, book, magazine, newspaper, musical composition, audio-visual work, radio or television program, or other types of newsworthy events. This is where the First Amendment has been enshrined and protected as a limit on the scope of the positive right, so that, for example, documentaries and biographies can be made of famous people. Even then, of course, as an intellectual property lawyer, I can tell you that we regularly confront the issue of whether a use is too extensive and whether rights should be cleared to avoid even uncertainty of potential litigation. And for those of you back east, New York is similar with similar laws that it has codified and enacted in recent years. To understand deepfakes, here is what we could call an analog deepfake case. In the 1980s, we can consider the case of Bette Midler versus Ford, which went up to the Ninth Circuit in 1988, and you can read the opinion at 849 F. 2nd 460. Let me give you the facts before we actually watch the commercial that upset Midler. Ford Motor Company wanted to do an ad campaign for its Mercury Sable car that was meant to inspire nostalgia for the 1970s. As a result, it wanted a famous 1970s song to be sung by the original artist who recorded it. It chose the song Do You Want to Dance, which was one of the songs Bette Midler recorded on one of her commercial music albums. The Ford Motor Company cleared the copyright interests from the copyright holder of the musical composition, which was not Bette Midler, and it then asked Bette Midler to record the song for the commercial. She did not want to do it, and so as a result, Ford hired a voice impersonator of Midler and had that person sing the song. And Ford also did not use her name or image in the commercial. In other words, it did not use someone who looked like her and perhaps danced like her, as in the case of Nancy Sinatra and the Goodyear Tire Company. It got a sound-alike. Let's now watch the commercial. I have only taken part of it, enough for you to get the idea of what was happening as it relates to a voice impersonation claim. If you want to see it all, the YouTube link is there for you.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road.
Wanna dance?
Introducing Sable.
Do you wanna dance?
Mercury, the shape you want to be in.
Well, there you have it. And what did the Ninth Circuit hold? You can see the holding there, which sums up the right of publicity standard pretty well. The court held, why did the defendants ask her to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct that sound-alike to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of her identity. Its value was what the market would have paid for her to sing the commercial in person. And here is a key line which now echoes through the decades to our modern day. The human voice is one of the most palpable ways identity is manifested. The Ninth Circuit also addressed these First Amendment concerns that we have already alluded to in the human cannonball case and in the statutory exceptions, by noting that the First Amendment is broad and gives a lot of leeway to the press. But where the purpose of a use in media is informative or cultural, then that use can be immune in terms of First Amendment news gathering issues. But if the media's use of a person's identity is centrally related to exploiting the individual portrayed for commercial gain, then the First Amendment gates are essentially slammed shut, and there will be no immunity. This is a massive case in the realm of voice that has long-lasting consequences as we enter the artificial intelligence age, where voices can now be recreated without having to hire expensive imitator actors. Finally, it is also worth mentioning what happened after the Ninth Circuit remanded the case. Well, it went to trial, and the jury awarded Bette Midler $400,000 in damages. The defendants appealed it all the way to the United States Supreme Court, but the Supreme Court refused to take up the case. So it was not a computer that made the voice, and was a person meant to be like her. And rather than use an AI machine, a real actor was used. Put differently, it was an analog-era deepfake, basically, and they lost. That will help us understand deepfakes as we get to technology creations of voices and answer the Scarlett Johansson question. Before we get to the modern AI age, there is one more stop, and that is the case of Tom Waits against the Frito-Lay Potato Chip Company. This case picked up on the Bette Midler case. It is reported at 978 F. 2nd 1093 from the Ninth Circuit in 1992. This time, singer Tom Waits found that a voice imitator had sang in a voice that sounded like his famed raspy voice in a commercial for Doritos. He was concerned because he realized immediately that anyone that saw the commercial and heard the commercial would assume that he had done a commercial for Doritos. And this particularly bothered him because he had made it a point in his career to not be commercial at all, often stating that artists should not do commercials because it damages their craft. Let's first check out part of the commercial.
There's a new tortilla chip called Salsa Rio Doritos. It's buffo, bafo, bravo, gung-ho, tally-ho, but never mellow.
Tickle your taste on the tangy tomatoes, flavor peppers, oodles of onions and sassy spices. A new Salsa Rio Doritos.
Now that tongue tickler's quite a stickler. It's confounding, resounding, perplexing, complex, and involuted, convoluted, but it sure feels.
Well, after that commercial and his lawsuit, the case went before a jury. The jury in turn awarded him $2.6 million in compensatory damages, punitive damages, as well as attorney's fees. The facts here, as in Midler, showed that the defendant specifically hired a sound-alike and really wanted a commercial that evoked Tom's voice. The court found that the situation was one of a deliberate imitation of his voice, as opposed to simply appropriating his style, and that his voice was sufficiently distinctive and widely known to give him a protectable right under California right of publicity laws. See here the bolded language, which is important, where the court held that this claim was based on an invasion of a personal property right, the right to control the use of a person's identity, where that identity is embodied in voice. That importance of protecting voice as an aspect of one's identity is the core of deepfake voice cases. And it now matters to everyone with cheap technology that can do this quickly with a phone. After all, back in the day, no one needed to copy the average person's voice with great expense. But with cheap, ubiquitous technology, everyone's voice is fair game now for all manner of uses one can imagine. So now let's enter the 21st century in the realm of artificial intelligence and the Scarlett Johansson situation of 2024. In 2024, the facts as publicly reported appear as follows. OpenAI asked her if they could use her voice as a voice in the artificial intelligence systems they were creating. Imagine something like Siri that we all know from our Apple phones, but far more advanced. She declined. Nonetheless, OpenAI then released its most recent version of ChatGPT with a voice assistant who goes by the name of Sky. When the commercial was released, many people felt as if Sky sounded like Scarlett Johansson. She certainly did, and it is reported that she hired lawyers and complained. No doubt her lawyer's letter cited the Bette Midler and Tom Waits cases. Here is the commercial again. So you listen for yourself and make your own decisions about the legal and factual questions of similarity and use. We will then discuss it within the right of publicity framework. Here you go.
From right of the ChatGPT app, and this will open up GPT-4o's audio capabilities. Hey, ChatGPT, I'm Mark. How are you?
Oh, Mark. I'm doing great. Thanks for asking. How about you?
Hey, so I'm on stage right now. I'm doing a live demo, and frankly, I'm feeling a little bit nervous. Can you help me calm my nerves a little bit?
Oh, you're doing a live demo right now? That's awesome. Just take a deep breath. And remember, you're the expert here.
To me, it does sound like her indeed. Now, to be clear, this is not a slam dunk. Many people, when you read online discussions, say that it does not sound like her. This gets to one of the core fact issues that exists in these voice cases. Is the second voice, in fact, an imitation of the first voice? We don't know what happened in the conversations between her lawyers and OpenAI, of course. But Sky has been taken down in terms of that voice, and this raises a variety of issues. First, was the voice of Sky AI generated, or was it a voice imitator actor? If it was a human actor, then this looks very much like the Midler and Waits case, which would then raise the legal questions within right of publicity law of whether this was a knowing use of her distinctive and valuable voice in a commercial manner. After all, they tried to hire her and she refused. This fact is powerful to merge with facts of voice similarity to conclude the second voice is indeed a copy of hers. Second, there still remain complex fact questions about the distinctiveness of the voice. A Midler sound-alike singing a Midler song on those facts seems easier. The same for Waits with his particularly unique raspy voice. But it gets harder when a voice is not being used in an associational manner with the person, as was squarely the case in Midler, and just sounds a bit like someone who is not known for a distinctive voice, in contrast to the Waits case. On the other hand, if the voice was AI generated, then it raises similar right of publicity questions. As a factual matter, it obviously gets more complicated because a voice imitator is hired to imitate a voice, and that makes proof of the knowing element easier. but whether the AI machine has learned human voices by listening to thousands or millions of hours of human voice and has generated that voice is a slightly different question. It is harder to prove that it was trained on her voice in particular, or whether it was simply trained on voices, and the voice it landed on sounded somewhat like hers. In other words, was this a knowing use under right of publicity law? So this gets us to deepfakes. And now let's look at the state deepfake laws being added to the books to combat the technologies that are driving these questions. As we just saw, existing state right of publicity laws are not perfect for AI and deepfakes, so there are new state laws afoot. Here we will look at California's newest laws to try to address deepfakes and the broad scope of use of the technology that can inflict harm. The first one relates to politicians, which I guess makes sense since they want to legislate to protect themselves first and foremost, if we are to be a little cynical. Here we have AB 730. It prohibits distribution of materially deceptive audio or visual media of candidates within 60 days of an election. And materially deceptive audio or visual media includes an intentionally manipulated image, audio, or video recording of a candidate that would both falsely appear to a reasonable person to be authentic and would cause a reasonable person to have a fundamentally different understanding or impression of the expressive content than that person would have if they were hearing or seeing the unaltered original version of the content. Then we have AB 602. It creates a private right of action for individuals depicted in sexually explicit deepfake material without consent. Then more recently, we have some new proposed laws in 2024. These address AI-generated election content and require platforms to implement procedures. All are examples of gaps in the law given the default right of publicity framework we looked at. Let's look in more detail now at AB 602. It creates a private cause of action against a person who either 1. Creates and intentionally discloses sexually explicit material where the person knows or reasonably should have known the depicted individual did not consent to the creation or disclosure, or 2. Intentionally discloses sexually explicit material that the person did not create, and the person knows that the depicted individual did not consent to the creation of the material. A depicted individual is an individual who appears as a result of digitization to be giving a performance they did not actually perform or to be performing in an altered depiction. It also exempts a person from liability if the material was disclosed at a legal proceeding, to report unlawful activity, or if the material is a matter of legitimate public concern, a political or newsworthy work, or is otherwise protected by the Constitution. A successful plaintiff can recover either economic and non-economic damages proximately caused, including emotional distress, or statutory damages of at least $1,500, but no more than $30,000. But if the act was done with malice, then up to $150,000. Also, punitive damages, attorney's fees and costs, and injunctive relief are available. So this addresses what default state law does not: a non-commercial deepfake and a use that may be more limited, such as circulating among friends improper deepfake pictures. As it stands in 2025, we have 27 states that have individually addressed deepfakes with some sort of legislation, have specific ones like we looked at in California, other ones such as Tennessee that have protected voices in particular, and then we have New York, which has actually combined the right of publicity and deepfake regulation and has a more broad-based set of legal protections like California. You can see on the chart here our breakdown of various state approaches in terms of what they are protecting, and you can see the vast majority are specifically addressing sexual deepfake situations. Multiple lawsuits have been filed to address restrictions on political commentary in the new 2024 laws we just looked at. Here is California's AB 2839 law. The maker of a Harris parody video sued to get an injunction on the political aspects to California's laws. Here are the facts from the court. His videos contain demonstrably false information that include sounds or visuals that are significantly edited or digitally generated using artificial intelligence. Here is the video at issue. In it, he used AI technology to make Vice President Harris's voice manipulated to say things she has not said, including that she is the ultimate diversity hire and that she has spent 4 years under the tutelage of the ultimate deep state puppet. And in court, the Harris parodist got an injunction too. Here's what the court said. Almost any digitally altered content, when left up to an arbitrary individual on the internet, could be considered harmful. For example, AI-generated approximate numbers on voter turnout could be considered false content that reasonably undermines confidence in the outcome of an election under this statute. On the other hand, many harmful depictions, when shown to a variety of individuals, may not ultimately influence electoral prospects or undermine confidence in an election at all. As plaintiff persuasively points out, AB 2839 relies on various subjective terms and awkwardly phrased mens rea, which has the effect of implicating vast amounts of political and constitutionally protected speech. The record demonstrates that the state of California has a strong interest in preserving election integrity and addressing artificially manipulated content. However, California's interest and the hardship the state faces are minimal when measured against the gravity of First Amendment values at stake and the ongoing constitutional violations that plaintiff and other similarly situated content creators experience while having their speech chilled." End quote. Here is what the court then ultimately held. Quote, "While a well-founded fear of a digitally manipulated media landscape may be justified, this fear does not give legislators unbridled license to bulldoze over the long-standing tradition of critique, parody, and satire protected by the First Amendment. YouTube videos, Facebook posts, and X tweets are the newspaper advertisements and political cartoons of today, and the First Amendment protects an individual's right to speak, regardless of the new medium these critiques may take." End quote. As we think about deepfakes, another area is in robocalls to sell us things or deliver messages. The FCC is one of the first federal agencies to use regulatory power against deepfake technology, focusing specifically on AI-generated voice deepfakes used in robocalls. In February 2024, the FCC adopted a ruling that recognizes calls made with AI-generated voices are artificial under the Telephone Consumer Protection Act. This ruling made AI voice deepfakes in robocalls illegal without prior express consent of the called party. It is a significant development because it does not require new legislation, but rather interprets extant law to encompass the new technology that is employed in deepfakes. This gives broader power to the feds and state attorney generals to enforce these restrictions against improper robocall entities. Now let's look at an actual FCC case brought about deepfake robocalls. Here's what the FCC did with this deepfake of President Biden. The deepfake said this in Biden's voice. Quote, "This coming Tuesday is the New Hampshire presidential preference primary. Republicans have been trying to push nonpartisan and Democratic voters to participate in their primary. What a bunch of malarkey. We know the value of voting Democratic when our votes count. It's important that you save your vote for the November election. We'll need your help in electing Democrats up and down the ticket. Voting this Tuesday only enables the Republicans in their quest to elect Donald Trump again. Your vote makes a difference in November, not this Tuesday. If you would like to be removed from future calls, please press 2 now." The FCC in turn imposed a penalty of $6 million against Steve Kramer for effectuating an illegal robocall campaign that targeted potential New Hampshire voters 2 days before the state's 2024 Democratic presidential primary election. Because Kramer's robocalls carried a deepfake generative artificial intelligence voice message that imitated U.S. President Joe Biden's voice and encouraged potential voters not to vote in the then upcoming primary election, they were violative of truth and caller ID laws and telephone consumer protection laws. The caller ID information was inaccurate and misleading as the calls transmitted the telephone number associated with a prominent New Hampshire political operative. But in reality, Kramer, without the knowledge or consent of the individual whose telephone number was identified in the caller ID, was responsible for the spoofed robocalls. On the federal side, Beside agency action on existing laws, there is a broad pending federal landscape, so we will look at some of the pending federal laws, starting with the No Fakes Act. The No Fakes Act is probably the most comprehensive federal effort to address deepfakes. It was introduced by a bipartisan group of senators, including Chris Coons, Marsha Blackburn, and Amy Klobuchar. This bill would establish the first federal right to control one's own image and voice. It recognizes that every individual has a federal intellectual property right to their own voice and likeness, including an extension of that right for the families of individuals after they pass away. That is a very broad nationalization of the otherwise state-based right to publicity. At the same time, it includes safeguards intended to protect First Amendment rights for protected speech such as biopics, docudramas, parody, and satire. A second one is the Defiance Act. This represents another significant federal proposal aimed specifically at sexually explicit deepfakes. The bill would create a federal civil remedy for victims of non-consensual sexually explicit deepfakes, allowing them to sue those who create, distribute, or possess with intent to distribute such content. It defines non-consensual sexually explicit deepfakes as visual depictions created through technological means to falsely appear authentic that depict a person in the nude or engaged in sexually explicit conduct or sexual scenarios. So as you see, this is similar but narrower as it is focused on sexually explicit creations. Let's now look at another one, called the Deepfake Accountability Act, in more detail. This act, if passed, creates a legal obligation for those who create deepfakes through generative artificial intelligence and do not label the video or audio file as having been made through AI. It applies to both living and deceased people. And a deepfake is defined as having been made by generative artificial intelligence, whereby it appears to authentically depict either the speech or conduct of a person who did not engage in that speech or conduct. Note, however, it does not apply to voice actors who do verbal impersonations. I won't read the whole definition for you, but you can see it here for a few moments and study it further in the materials. If someone makes such AI deepfake content and does so with the intent to distribute it over the internet, or even with knowledge that it will be distributed over the internet, then they must make sure that the file clearly identifies itself as being made through technology, with altered audio or visual elements, or having been created by AI. There are specific labeling requirements the law will require in terms of a verbal statement that identifies the use of artificial intelligence, as well as a clear written statement in readable text throughout the whole video, identifying it as having been made by artificial intelligence. And no, this does not mean you can make deepfake porn of people and just label it. Sexual deepfakes are to be per se outlawed. I have bolded the content for you to read here that is germane to our discussion today. Moreover, there are provisions for civil liability. These actually track somewhat existing remedial structures that exist in the U.S. Copyright Act. And what the statute as envisioned provides is that if someone has been exhibited and engaging in activity that is falsified by way of deepfake technology, then they may seek damages and injunctive relief in federal court. The statutory damages structure includes a $50,000 penalty, a $100,000 penalty, potentially if the conduct was more extreme, and a $150,000 penalty if it is deepfake content involving sexual activity or nudity. The damages include both actual damages, but then also this statutory damages regime, similar to copyright infringement, liability damages, regimes that exist for copyright statutory damages, where the awards can be to an extent divorced from actual harm and are focused on deterrence and punishment. And there are broad injunctive relief powers available to federal courts to enforce the laws. And as a word of warning, do not let your clients think that until this law is passed, that they are operating on a blank check to do what they want as it relates to artificial intelligence technology. Aside from the state right of publicity laws that we have discussed, there are a variety of state laws that various states have enacted specifically to address improper deep fakes, particularly in sexual and nudity subject matter areas. Finally, as noted, this is not the only pending federal law. There are other pending bills that seek to achieve similar legislation over the area, all of which legislation amounts to a partial, at least nationalization of the right to publicity. The legal landscape here is changing rapidly, so stay tuned and watch our programs as we update the state of the law as this develops. Also, as you can see, there are criminal penalties for those who fail to disclose. It is to be criminal to make deepfake porn where the deepfake contains sexual content or visual nudity and appears to simulate people engaging in sexual activity, as well as videos that are made with the intent to cause violence, harm, or diplomatic conflict, or interfere in official elections, assuming the advanced record does in fact pose a credible threat of instigating such conduct. It will also apply to the use of deepfakes in identity theft, wire fraud, securities fraud, and apply to any foreign power or agents of foreign governments who act with the intent to influence any kind of a public policy debate or even an election. As you can see, there are some pretty facially broad applications of this statute, which in some of these contexts may well collide with the First Amendment as currently structured. Specifically, there will be questions raised about the ability to criminalize speech that influences a public policy debate. One can imagine that all manner of speech about social issues, such as abortion, or the right to have guns, or immigration policy, relates to public policy debates, and this act will, if passed, criminalize foreign agents from engaging in that speech on our media platforms. Some deepfakes can have good social purposes, even outside the consent example of Val Kilmer, or the satire example of the political video of Harris. There is news reporting, social commentary, parody, and satire that needs protection in creative expression. And deepfakes allow people to engage in these activities at a more breathtaking pace than ever before. Not just video, but voice and then video and voice together gives a technology platform to create in new ways and harm in new ways, and the laws have to balance all interests. The state and federal laws, thus all, are moving incrementally in protecting rights of all stakeholders, not just the first-level victims of a deepfake. Let's look at an existing pre-deepfake case to see how the First Amendment issues play out in these cases. This will bring us to the ever-hilarious Three Stooges. Here are the facts from a California Supreme Court decisions balancing First Amendment expression rights with the right of publicity against another's use. Plaintiff Comedy is the registered owner of all rights to the former Comedy Act known as the Three Stooges. Defendant is an artist with over 25 years' experience in making charcoal drawings of celebrities. These drawings are used to create lithographic and silk screen masters, which in turn are used to produce multiple reproductions in the form, respectively, of lithographic prints and silk-screened images on T-shirts. Defendant sold lithographs and T-shirts bearing a likeness of the Three Stooges reproduced from a charcoal drawing he had made. The court found for plaintiff and awarded $75,000 in damages. Defendant argued that enforcement of the judgment against him violates his right of free speech and expression under the First Amendment. The Supreme Court saw this as a difficult issue. Let's read what it said here and then how it ruled. Because the First Amendment does not protect false and misleading commercial speech, and because even non-misleading commercial speech is generally subject to somewhat lesser First Amendment protection, the right of publicity may often trump the right of advertisers to make use of celebrity figures. But the present case does not concern commercial speech. As the trial court found, Satirup's portraits of the Three Stooges are expressive works and not an advertisement for or endorsement of a product. As such, it said that, it then stated, the very importance of celebrities in society means that the right of publicity has the potential of censoring significant expression by suppressing alternative versions of celebrity images that are iconoclastic, irreverent, or otherwise attempt to redefine the celebrity's meaning. The right to self-expression is inherent in any political system which respects individual dignity. Each speaker must be free of government restraint, regardless of the nature or manner of the views expressed, unless there is a compelling reason to the contrary. The right of publicity has a potential for frustrating the fulfillment of both these purposes. But those principles, even if not adopted by the trial court, did not support the artist here. The Supreme Court said, turning to his work, we can discern no significant transformative or creative contribution. His undeniable skill is manifestly subordinated to the overall goal of creating literal, conventional depictions of the Three Stooges so as to exploit their fame. Indeed, were we to decide that Satyrup's depictions were protected by the First Amendment, we cannot perceive how the right of publicity would remain a viable right, other than in cases of falsified celebrity endorsements. And here is the key point. It held, quote, Satyrup argues that it would be incongruous and unjust to protect parodies and other distortions of celebrity figures, but not wholesome reverential portraits of such celebrities. The test we articulate today, however, does not express a value judgment or preference for one type of depiction over another. Rather, it reflects a recognition that the legislature has granted to the heirs and assigns of celebrities the property right to exploit the celebrities' images, and that certain forms of expressive activity protected by the First Amendment fall outside the boundaries of that right. Stated another way, we are concerned not with whether conventional celebrity images should be produced, but with who produces them, and more pertinently, who appropriates the value from their production. Thus, under Section 990, if Satyrup wishes to continue to depict the Three Stooges as he has done, he may do so only with the consent of the right of publicity holder. End quote. So you can see there that the First Amendment balancing exists in existing law, and parody or truly transformative uses are okay, but pure commercial exploitation is not. Here are our conclusions today as it relates to deepfakes and the law for you, so that you can understand both how to advise clients who may be finding themselves confronting potential liability, or clients who may be victims and need to seek redress in the courts. The technology is incredible and has great power to do social good as well as harm. Laws need to balance that at the end of the day so we do not throw the baby out with any bad bathwater. Fundamentally, there are existing legal regimes in the states that can address deep fakes, but they are limited both in terms of which states have right of publicity protections, but also in terms of the substantive scope of right of publicity protections. Generally, there is the need for a commercial use which tends to exempt a range of political or sexually explicit revenge porn type deepfakes. This evolving legal framework, therefore, now includes a variety of new state laws that have been enacted to combat deepfakes, as well as several pending federal laws. We looked at all of them, and you can make your own decision about what you think is the best approach. We saw the limited state-by-state approach to the limited federal approach of addressing political speech and sexually explicit deepfakes, all the way to the broader federal approach of essentially providing nationwide full right of publicity type protection, almost preempting or supplanting the state regimes. One of the through lines we saw that really goes from the inception of state right of publicity ideas all the way through the pending federal laws, the new state laws, and the case law that we looked at, is the importance of balancing First Amendment expression ideas with protecting against commercial misappropriation or other misappropriation of people's names or likenesses. We saw two examples. We saw the U.S. Supreme Court closely denying First Amendment rights to news outlets to take the human cannonball's entire act. And we saw the California Supreme Court specifically in the Three Stooges case. There we could see how California balanced those issues and came down against using a right of publicity to sell t-shirts, even if it was expressive art. And we saw the language in the pending federal and state laws designed to address those issues. At the same time, we saw in one example, one federal court has already enjoined California's deepfake law as it relates to political speech, finding that people have the right to engage in deepfake technology use to engage in political satire. How these interests continue to be balanced will evolve over time. So stay tuned as you watch for the future development in this area to make sure you are fully aware of the current state of the law. Finally, I would submit that federal legislation offers a path towards more uniform protection, and that raises the question of whether we should simply nationalize the right of publicity for both commercial uses, but also for sexually explicit uses political speech, the full spectrum, and thereby have a federal platform with federal court injunctive relief power to address these issues. And as we saw, because of the immunity from state tort law that service providers have, there needs to be in all of these laws some mechanism to mandate takedowns, as we have in the copyright realm, when there is a deep fake that is improper being used. Thank you as always, and as always, if you have questions, please reach out and email me.